Dear colleagues, I have to spend some minutes in order to express my deep gratitude to Faculty of Law, especially to Charles. It's the first time that I'm in Lithuania, and it is not Vilnius but Kaunas. Thank you very much indeed. Actually, I have to make some corrections because of the limit of time, and I'm not going to speak of all legal professions in Russia. I'm going to concentrate my report only on the basic or crucial profession, I mean the profession of judge. So actually my report is named on ethical dimension of the profession of judge in Russia. And some preliminary remarks. Speaking of moral standards in the legal profession, one is tempted to give some general notion in the sense of ethical naturalism. In other words, one is tempted to explore the goodness of moral standards as if they were ontology of goodness. And this approach is likely to degenerate in the caricature version of Platonism, when the explorers uses the term goodness in the same sense as a Platonic idealist would use words tableness, hoarseness, or setness, etc. Ethics operates with highly abstract notions which are often ambiguous at the same time. For example, the word reputation. This word may be understood in the subjective sense, that is, as the reputation of a particular judge, for example. But it may also be understood in the objective sense, as the reputation of a judge's office or profession of judges. And this interplay of the subjective and objective aspects, perhaps of any moral categories, is very important, but it is often underestimated in practice. So I do not know whether goodness exists as an eternal, undisturbable idea, and I think that this question is not to the point so long as our matter under discussion confines itself to moral standards of judges. And I would like to make some propositions, first of all. Proposition number one. In Russia or elsewhere, moral standards of lawyers or judges are always relativists. They are never absolute. Even if a judge is eager to maintain high personal standards of the professional ethics, somewhere, sometime he is certain to fail if most of his colleagues are more or less corrupt, as it is sometimes the case in the contemporary Russia. And the only possibility for such a judge to preserve her or his moral integrity would be either to develop and maintain the characteristics of the early Christians, I don't know, or simply apply for an office somewhere else. Proposition number two. There isn't such a thing as the legal profession in the singular. Accordingly, moral standards of various legal professions may vary considerably among themselves. And proposition number three. The legal ethics is functional, in the sense that the moral content of professional legal behavior is very resilient. It may easily contract or expand around some constant ethical minimum. And this is exactly the point. If there is the notion of the ethical minimum for judges in Russia, for this purpose I have investigated the history of the Code of Judges' Ethics. Actually, there were three such codes. The Code of Judges' Ethics currently in force was adopted by the 8th Congress of Russian Judges on the 19th December of 2012. The previous one was adopted by the deputies of the 6th Congress of Judges on the 2nd December of 2004, and replaced the analogous code of the Russian Federation that was in force since the 21st of December of 1993, that is since Yeltsin's time. The Yeltsin's code bore a rather pompous name. It had the title, The Dignity Code of the Judge of the Russian Federation. So let's compare the code of 2012 with the code of 2004. To begin with, in the short preamble, the code of 2004 singles out fairness and independence of judges as the core categories. The latter may have ethical dimension, of course, but in the Russian legal mentality, the term independence, when applied to judges, has the undeniable legal content. Besides, independence of judges can be legally formalized, but it is impossible to formalize fairness. Using the Wittgenstein's metaphor, we only can grasp what fairness is about by a method of finger pointing. Just we can point a finger at something and say that fairness is neglected in this case, for example. So we can say that the preamble of the Code of 2004 tacitly contains a dubious tendency to combine ethical approach, the key word is fairness, with the legalist approach, the key word is independence. According to the preamble, a Russian judge must take part in establishing and maintaining high norms of judges' ethics. End of quotation. Thus, one may expect that in the main body of the code, some effort is spent so as to enumerate the recommended nomenclature of mysterious high norms. Let's examine the main body. The structure of the code is the following. Chapter 1, it is called General Demands Concerning the Conduct of Judges. Chapter 2, Rules of Professional Conduct of Judges. Chapter 3, Rules of Extra-Professional Conduct of Judges. Chapter 4, Responsibility of Judges for Violation of the Code's Demands. And Chapter 5, Coming in Force of the Code and Limits of its Application. Let's come back to Chapter 1. There are only three general demands, only three paragraphs in this chapter. Firstly, there is reiterated the necessity for judges to observe the Russian Constitution of 1993, the Federal Act on the Status of Judges of the Russian Federation of 1992, and other legislative acts. All that stuff has little to do with specific ethics of judges, of course. The second paragraph stresses the so-called professional priority. In other words, the content of the Article 2 boils down to the following tautology: a judge must be a judge in the first place. The third paragraph says, at any rate, a Russian judge must preserve her personal dignity and honor. She must avoid anything that could diminish the authority of the adjudicative power or her reputation as a judge, or cast doubt on her professional objectivity and independence. Thus, only Article 3 contains something that may be termed as professional ethics of a judge. There are three key words here: reputation, objectivity, and once again, independence. Chapter 2 stresses the essence of the profession. The essence of the judge's profession is protection of human rights and freedoms in particular cases. Again, there is nothing especially ethical in this standard. The professional activity of a judge is governed by the principle of good faith, impartiality, tolerance, politeness, and tactfulness. Among these, only the principle of impartiality may be regarded as a professional ethical imperative. The rest fall into the category of general ethics. Chapter 3 postulates two principles which must guide the extra-professional behavior of a judge. They are uprightness, in Russian порядочность, and honesty. Due to the fact that I am not a native speaker of English, I cannot see the difference between uprightness and honesty. But as a Russian, I cannot see the difference between порядочность, uprightness, in chestness, honesty either. Thus, in the private sphere, a Russian judge must remain honest. Whether preserving honesty at any rate, a Russian judge may practice partiality or intolerance or even racial bias in her private affairs remains an open question. Chapter 4 virtually has no relevance of its own because as far as negative sanctions are concerned, the Code of 2004 takes sides with the mentioned Federal Act on the Status of Judges of the Russian Federation of 1992. This outcome was quite predictable because ethics has no external sanctions of its own. Let's briefly analyze the Code of 2012 currently in force. There is one obvious formal difference because the Code of 2012 is almost twice as big as the Code of 2004. In principle, the Code of 2012 retains the structure of the Code of 2004, but if we take a closer look at new provisions, then we would mostly encounter rules of external constraints, which is rather unusual with ethical norms. Examples of such newly established external constraints for judges are numerous. Many of them deal with personal and family property of judges, as well as with the financial activity of them and of their close relatives. For example, no judge shall conclude contracts entailing her financial obligations with subordinate officers or clerks, or parties to a trial being adjudicated by the specific judge. Article 6, Part 2. Further, no judge shall misuse her status for commercial gains or for eliciting benefits, disbursements, privileges from other persons. And moreover, each judge has to stop the analogous activity of her family members. Article 6, Part 3. The clearly ethical dimensions has, for example, the provision of Article 12, Part 6, which stipulates the ban of nepotism among judges. Thus, a president of a specific court shall avoid the practice of making unfounded appointments. Thus, the novelty of the Code of 2012 as compared to the Code of 2004 consists largely in additional norms regulating some administrative functions of senior judges. Paradoxically, as it may seem, the normative extension of the Code of Judges Ethics of 2012 in comparison with the more compact Code of 2004 was extra ethical in many respects and was effectuated in the vein of the Federal Act on the Status of Judges of the Russian Federation of 1992. To sum up, we may conclude that the main function of introduction of the Code of Judges Ethics was the necessity to systematize the fight against corruption in general and to reinforce this fight among judges in particular. And the second aim was the desire of the ruling class to make the Russian machinery of justice more effective and less tiresome for ordinary people. And the second paradox, to my mind, consists in the obvious discrepancy between the declarative ambition of both analyzed codes and the constitutive scarcity of ethical norms. Anyone agrees that a judge shall be a judge with no intention to be a clandestine businessman or a politician. There is nothing intrinsically ethical about it. It is unbelievable that a Russian judge does not know that she must be conscientious as far as her professional duties are concerned, that she must be honest, tolerant, and objective. But I doubt that these trivialities deserve the status of special ethical norms for judges. They are general norms written in the hearts of all decent people. Thus, the essence of each code boils down to the statement in the vein of George Orwell, like this: all Russian judges are equal, but decent Russian judges are more equal. Thank you very much.